like to start off by quoting Henri LaHood, who is a U.S. representative in Congress from the state of Illinois. I support the death penalty. However, I believe there must be 100% certainty when the death penalty is administered. A just society cannot engage in taking of an innocent life. Our nation's system is fatally flawed, and we must ensure that every possible legal and technological method is provided to determine the guilt in capital cases. Now, the death penalty it's not thorough enough, and it should be, because we're dealing with someone's life on the line. So this leads me to my main proposition, which is the judicial system is likely to make mistakes in the position of the death penalty, and I will be providing cases and acts that are highly controversial and not thorough enough to protect the death row inmates. Now, to start off with the case of Anthony Porter, and it's from the statement of Henri LaHood, who is a U.S. representative in Congress, and it was from a hearing. And the case of Anthony Porter, Porter was 2 days away from being executed for allegedly killing 2 people in 1982. Due to a temporary stay of execution with questions over his mental competence and his low IQ, journalism students from Northwestern University obtained a videotaped confession from the killer and an affidavit from a witness who admitted he gave a testament about the case. Without those students, Anthony Porter could have been executed. Now, this just points out a major flaw in our judicial process when it comes to the death penalty. If it weren't for those students, he would have been executed, and he was innocent. He wasn't the one who committed the crime. And I'll be giving some statistics from a study in Colombia, which said that 25% of cases involve a false confession of incriminating statements made by the defendant, or of those cases, 35% were 18 under and or developmentally disabled. And there's another study in Colombia that stated that it examined 4,000 capital cases, and in 28 states over a 23-year period, the study concluded that 7 out of every death penalty cases contained serious irreversible error. So, as we can see, the judicial system when it comes to the death penalty is crucially flawed, and it doesn't have the essentials to execute such thing. And I'll be talking about the execution of Troy Davis, which clearly points out another flaw in the judicial process and how it endangers innocent people on the death row. Now, Troy Davis was executed, and this was from an article on Life Science that briefly explained his case. Now, on September 21st, Georgia executed Troy Davis despite significant doubts about his guilt and urgent requests from national and international leaders to spare his life. Davis had been convicted principally on the basis of eyewitness testimony, a form of evidence that has recently come under scrutiny. Years after his trial, 7 out of the 9 state witnesses against Davis changed their stories. The federal judge in Savannah conducted a hearing to review the new evidence, but in order to grant Davis a new trial, the judge required not only that he establish reasonable doubt of his guilt, but that he provided clear proof of his innocence, which he was unable to do to the judge's satisfaction. Now, the execution of Troy Davis was really big in the news, because there's the eyewitnesses who they changed their mind. 7 out of 9 witnesses changed their mind about that it wasn't him, and they still carried on with the execution. And this leads me to an article on the Encyclopedia of American Civil Liberties Unit. It says that in several cases, college or law school students investigated cases and unearthed essential evidence. For example, students in an investigative journal class at Western University uncovered evidence of misconduct by prosecutors who talked a witness into giving a false testimony and withheld crucial trial evidence. Sorry. Oh God. Now I'm just gonna move on to my second supporting claim, which is that death row inmates are defended by incompetent lawyers, and I will be providing a case of Leroy White. Now, to support my claim, there was an investigation by the Texas Defense Service, and they found that death row inmates today face a 1 in 3 chance of being executed without having the case properly investigated by a competent attorney, and without having any claims of innocence or unfairness presented or heard. Now, the case of Leroy. Leroy was executed in Alabama on January 31st, 2011. And before the trial, prosecutors offered White a plea bargain that would have given him life without parole. The settlement failed when Mr. White's trial lawyer misunderstood the law and incorrectly told Mr. White that he could not be convicted of capital murder. The jury in White's case recommended a life sentence, but Alabama is one of the few states in the country that allows the judge to override the jury and was sentenced to death. One of White's appeals attorney withdrew from the case without telling White and admitted that he allowed his client to miss a critical appeal deadline, shortening the appeal process and expediting his execution. Now, these are people who have gone many years to study law, and committing such a crucial error at a crucial moment when it's coming down to someone's life, it just points out a major flaw in our judicial system when it comes to the death penalty. And from an article on the American Bar Association, it said that in a landmark study of capital cases from 1973 through 1995, 7 out of every 10 cases that were fully reviewed in court had serious constitutional reversible error. Although state courts threw out 47% of the capital convictions due to such error, 40% of the remaining death sentences were found also to have serious error upon federal review. The most common error prompting reversal of death sentences were grossly incompetent defense lawyers. Now, in conclusion, after stating several cases and pointing out how these death row inmates are defended by incompetent lawyers, I conclude that the judicial system is likely to make mistakes in the imposition of the death penalty.
All right, the claim is identified very clearly. The secondary points are really, you're not really previewing the secondary claims, you're kind of previewing your secondary evidence, and I think that you need to have a more definitive statement of what those supporting claims are going to be. You do a good job signposting them when you get to them, but they're not really in the preview. The first point, of course, takes up 5 minutes of your speech, and that's where most of your energy gets devoted to. The second point, you get to it pretty late in the process. Now you go 2 minutes overtime, which allows you to get in some extra information on that, so you need to be a little bit more discreet about some of these things. The cases that you look at, I think you want to focus more on those cases where there is some doubt of guilt. There are several cases that you cite that have to do with legal questioning, but don't necessarily have to do with the guilt of the accused. And so if you want to make the argument that the process is failing to adhere to the law or to protect the security of the law, I think that might be the way to go, as opposed to uncertainty over guilt, which seems to be implied by your original claim. I thought that the second point was actually pretty well developed, and you had some good statistical information on each of those points, and want to look at the audience a little bit once in a while during the presentation.